Hello and welcome to the Ken Verkaman Law Office Legal Podcast. This edition, we talk about the ignition interlock machines that drunk drivers have to put on their cars. So there was a challenge to the interlock machines by an out-of-state New Jersey driver who eventually pled guilty to a refusal to take the test, and then they were still ordered by the municipal court to put this in interlock machine on their car. By the way, what is an interlock machine? Well, in a DWI refusal case, it's a machine that in order to start your car, you got to blow into the tube. It determines if there's alcohol or not, and then while you're driving, periodically it'll say pull over, and you'll have to be retested. So, in the unpublished case of State versus Colson, the the defendant driver appealed the order directing him to install this interlock device on his vehicle. The defendant originally was charged with DWI refusal, reckless driving. He pled guilty to the refusal. The other charges were dismissed. He had a loss of license, the interlock, and to attend the drunk driving school IDRC. The municipal court judge had rejected the defense argument that the ignition interlock device did not apply to out-of-state drivers. The defendant appealed. The law division judge imposed the same sentence requiring the interlock. So then the defendant appealed up to the appellate division. But the appellate court was not persuaded and noted the plain language of the refusal statute did not exempt out-of-state drivers from the ignition interlock device requirement, and then basically punishes any person who violates the statute. So that's State versus Colson. For other information on the DWI and refusal cases, visit website njlaws.com. And for representation, contact Ken Verkamen's office, 732-572-0500. Thank you.